Well, I think it probably will now. I wish it wouldn't, but I think that trial's going away, so we can do August 10.
All right, great.
All right, thank you, folks.
Your Honor, we decided, if it's okay with the court, we would call that, that's set for motions, but that's also a plea deadline.
Very good. So if we can have an agreement, we'll do it that date. If not, we'll hear the motion to suppress.
Great, thank you.
Thank you, folks. All right, good morning, everyone. We're here today in State of Tennessee versus Hayden Berkebile, docket number 117131. In May, this indictment proceeded to trial. The defendant was convicted of criminally negligent homicide, Class E felony. The court referred him for a pre-sentence investigation report and revoked his bond, so he's been in custody since then. The court has reviewed the pre-sentence investigation report as well as the state sentencing memorandum and the court's file in this matter. So I'm going to turn it over to the state. General, your position as the sentencing.
Thank you, Your Honor. As a preliminary matter, we move the investigative report in as stated.
Any objection?
No objection.
Exhibit 1.
Your Honor, we have identified and filed a sentencing memorandum with 7 enhancement factors that we believe do apply in this particular case. And if the court would entertain, I am going to publish the particular screenshots that we did on the basis that it gives context to our argument. So the first enhancement factor that we believe applies is 4035-114-4, and that is a victim of the offense was particularly vulnerable because of the age or physical or mental disability. If the court will recall, the proof at trial established that the defendant was essentially on notice that the victim was suffering from depression and that she had suicidal tendencies back to the age of either 11 or 13 years of age. The victim, Grace Ann Sparks, on several occasions and in several different ways, did inform the defendant that he was playing with fire when he went about having her engage in the suicide edge play for sexual gratification. If the court will note, on September 25th, 2019, in a message she did send to the defendant, "You're playing with fire, just keep that in mind." On August 30th, she did say, "Me hurts, not my body. I hurt inside. It doesn't feel good right now." She talks about in her messages that she hasn't recovered fully from last time and that going through these games opened old wounds. And on several occasions, she reached out to the defendant and asked if the suicide edge play could cease for a period of time. The next enhancement factor that we believe applies in this case is 4035-114-5. That is, the defendant treated or allowed a victim to be treated with exceptional cruelty during the commission of the offense. Our argument with regard to this particular enhancement factor is based on the length of the coercion. We would suggest that the proof established that the defendant again met the victim on a website called Omegle, which is a video site. We heard proof about that, where it links individuals with like interests. He was able to identify that the victim at that age did possess suicidal tendencies and ideologies, and he capitalized on that. We would suggest that he groomed her for the period of 8 years until he could get her in a position where he could have her take her life on video as he demanded in the messages. And to corroborate that, Your Honor, again, I would point the court to the messages that demonstrated on May 31st, 2017, the victim, Grace Ann Sparks, says, "I'm going to tell her how long it's been going on, how young I was, how I have your initials in my chest." On September 21st, she, in a discussion with the defendant, talks about underage wasn't a problem before, when the defendant, if the court will recall, became upset that she was drinking underage. The next enhancement factor that we believe applies is 4035-114-6. That is the personal injuries inflicted upon or the amount of damage to property sustained by or taken from the victim was particularly great. I think it goes without saying the victim in this case ultimately lost her life. If we consider the last day of her life and the demands the defendant was making, despite the victim having an otherwise a productive day, not engaged in those types of activities at that point, we would submit that the personal injuries inflicted upon her were grave as they resulted in her death. The next enhancement factor is 4035-114-7, and that is the offense involved the victim was committed to gratify the defendant's desire for pleasure or excitement. Your Honor, this particular enhancement factor, we would ask the court to give a great deal of weight. If the court will recall at trial, there was messages as well as the defendant's interview that indicated that the defendant would masturbate to the idea that the victim was pointing a gun at herself. He would use her before he would go to work as a bouncer at a strip club that he was employed by. That's evidenced by messages. The defendant on September 29th said, well, if it's enjoyment you're seeking, this conversation has caused me a hard-on I haven't felt in weeks. My heart rate is elevated. I can feel the adrenaline and I'm salivating. The defendant further says on September 20th, the thought of you staying up all night just to blow your head off for me after an orgasm is super fucking hot. On September 20th, I really want that behind you now as you blow your head off. August 30th, defendant says, I'm in the bathroom masturbating. And there's further details about the specifics in terms of how the victim was going to kill herself and how the defendant demanded that it be done through the use of a firearm that he was going to watch, or that she was not going to be granted his permission to take her life. The next, the next enhancement factor is TCA 4035-114-10, and that is the defendant had no hesitation about committing a crime when the risk to human life was high. This kind of correlates and kind of intertwines with 4 as we identified above. The risk to human life in this case was significantly high. The victim herself put the defendant on notice on several different occasions that she was becoming closer. She talked in communications with the defendant about the toll it was taking on her. The defendant had little to no hesitation about committing the crime when he knew the likely result was going to be that Ms. Sparks would take her own life in the manner that he demanded she do it. The next enhancement factor is TCA 4035-114-14, and that is the, the defendant abused a position of public or private trust or used a professional license in a manner that significantly facilitated the commission or fulfillment of the offense. What hinges on this particular enhancement factor is the abuse of a position of private trust. We would submit that the proof at trial demonstrated that the victim was trusting the defendant when they engaged in the suicide edge play. And she made that clear on several occasions that she did not actually want to die, that she did not actually want to be hurt. And she laid out to the defendant through messages that I'm trusting you to not actually kill me, not actually take my life. I'm engaging in these games for your sexual gratification. On September 16th, the victim sends, I trust you, even if in the moment I'd be scared. She further sends on September 16th, you wouldn't let me die, right? And if the court will recall about the date of the victim's death, things were different. The defendant and the victim were engaged in Russian roulette at the defendant's demand, and he was upset because he could see the bullet, or the victim could see the bullet, and the victim went as far as to offer a compromise and to wear a blindfold so she could not see where the bullet was, and the defendant knew where the bullet was. On September 29th, the date of the victim's death, she says, I can close my eyes if you want and do it. She further says on the same day, I trust you to not actually kill me. She further says on September 29th that she's afraid, but that she still trusts the defendant. And the last enhancement factor is 4035-114-17, and that is the defendant intentionally selected the person against whom the crime was committed or selected based on the perception regarding the race, religion, color, or disability of the victim in this case. And I'm paraphrasing this particular one as it's pretty lengthy, Your Honor. And we would submit with regard to this kind of has been addressed in some part, but this argument again would go to the fact that the defendant chose the victim based on her disability. He chose her based on his knowledge that she was suicidal, that she was young, and he exploited that. And what he did, Your Honor, is engaged in essentially a systematic campaign of coercion that ultimately resulted in her death. Ultimately, we do have to concede the defendant is a range 1 standard offender. He is looking at 1 to 2 years. There's obviously the court's discretion as to how he serves that. We believe that the conduct in this case, that it was atrocious, and that it warrants confinement, and that it warrants confinement for the maximum possible sentence in this case, which would be 2 years. And we're asking the court to impose a sentence of 2 years to serve in the Tennessee Department of Corrections.
Thank you, Mr. Sanchez. Does the family wish to present any victim impact testimony?
They do, Your Honor.
All right.
We can start with Chris, who is the uncle.
Sir, if you'd come forward to the podium, please. I'd like you to begin first by stating your name, your relationship to the victim, and then telling me how this has impacted you and your family.
Okay, my name's Chris Smith. I'm technically a cousin,
Gotcha.
but Grace Ann's father and I are more like brothers. So on March 22nd of 2000, Candace Sparks was in labor at St. Vincent's Hospital in Birmingham, Alabama. I was very excited because I was about to witness the birth of my cousin's first child. On that day, I became Uncle Chris, and I remain Uncle Chris. Grace Ann was a beautiful soul. She impacted our family in a very positive way. Some years later, I had children of my own, and Grace Ann was a mentor to my children. On the 29th of September, I received a phone call. I was traveling with my work. I was in Iowa. And Mr. Sparks called me, my cousin, to let me know she was gone. And I didn't understand. What do you mean she's gone? After gathering ourselves and doing some reflection, my kids, who are now late teenagers, reminded me of a time that in 2015, Mr. Sparks worked for me in Texas. And Grace Ann, after school, came and lived with us for about 2 months. I was in transition of moving my family to Texas, so my kids were also there. Now, I'd like to remind the court that in the testimony from Grace Ann, this started when she was 11 years old. The convict was at least 19, if not 20. The most formidable years of mental development. He was a predator then, he's a predator now. He convinced Grace Ann to hide everything from her family, including my children. My children remember them having conversations in 2015. And Grace Ann swore them to secrecy. You can't let your dad know, because he'll let my dad know. Now, we only have evidence from Facebook because it took 6-7 months before we could get a warrant to get his electronics. And in that time, he was able to wipe out everything. How many other victims are out there? Grace Ann can't be the only one, because this convict is the most vile and despicable type of person that you could ever imagine. Now, I'll tell you, I live daily with the suffering of her father with his PTSD over this incident. Every single day, I hear his anguish and his pain. It doesn't go away. Your Honor, we ask that you revoke any type of appeal bond and sentence him to the maximum. 2 years is a very light sentence for the lifetime of suffering that I will endure, the rest of my family will endure, and that Stephen and Candace Sparks endure on an hourly basis every single day. Thank you, Your Honor.
Thank you, Mr. Smith. I'm sorry for your loss.
Thank you.
Next, we have Hannah Kay Sparks, who is the sister of the victim. I believe she's appearing via Teams.
With Miss Fay.
She's not on.
Yeah, the only person, oh, there's Miss Fay.
Next, we'll have the victim's grandmother, Sandy.
Ma'am, if you come forward. Good morning. If you'd begin by stating your name, your relationship to the victim, and how this has impacted you, please.
I'm Sandra Parrish. I'm Grace Ann's grandmother.
All right, go ahead, ma'am.
First, I want to begin by thanking the state of Tennessee for the justice that our Gracie received. I also want to thank you, Judge. I want to thank Detective Chaz Terry, prosecutors Hector Sanchez and Rachel Lambert, and along with our guardian angel, Veronica Fay. Our family greatly appreciates the professionalism and outstanding expertise in which this trial was conducted. There would be many more people here for Grace Ann today if there could be. She would be represented from states Alabama, Texas, Florida, Tennessee, Montana, and Missouri. Health issues keep them from being here. COVID keeps them from being here. Job obligations keep them from being here. But we represent them today on her behalf. I am the grandmother of Grace Ann Sparks, but she let me call her Gracie. I was there on the day she was born, not just in the hospital, but I was in the birthing room with her mom and dad. I was one of the first people to lay eyes on that precious baby. It was a great day. There were so many hopes and dreams. It was just filled with happiness and joy. And then there was another day in Grace Ann's life, and it happened on September the 29th, 2019. I was doing some grocery shopping that day, and I received a phone call from my son. I could see his name on my cell phone, and I was excited because I thought, we'll talk, we'll visit with each other. I'll find out what's going on in his life right now, and we'll talk about things that mothers and sons talk about. But when I answered the phone, he said, Gracie is gone. Well, I thought, gone where? And he said, she's gone. And my first thought was, well, she's had an opportunity to travel. She's with friends having fun. And he said, she's gone and she's not coming back. So then I thought, well, she's moving away from Knoxville permanently. And then he said the unthinkable. Gracie took her life. I could not understand those words coming from his mouth. I was nauseated. I was sick to my stomach. I couldn't stand up. I was still shopping in the grocery store, and I sought a chair in the pharmacy area so that I could sit down and think about what he was telling me. Well, the mother part of me kicked in immediately, and I thought, I can fix this. I'll get to Tennessee as soon as possible. I'll fix this. I can take care of this. It'll be okay as soon as I get there. I can do this. But I could not fix this, and reality set in on my way home as I drove home to tell my husband what I had heard. I'll never see Gracie again. I'll never get to hear her voice on the other end of my cell phone asking me for a recipe that she wants to cook, one that we've shared together. I'll never take a ride in her new car that she had recently purchased. I'll never see her grandchildren, her children that would be my great-grandchildren. I'll never see what she could have accomplished in her life. Gracie is gone forever. We'll never get that back. But I want to tell you a little bit about Gracie because this should be about her. This day should be about her. I want to tell you things that you have no way of knowing. Gracie had beautiful blonde curls and bright blue eyes. She had a smile that would welcome you into her life with joy. She was intelligent. She was kind beyond measure. She was friendly and funny and just beautiful. When she was a toddler, she came to visit us in Alabama, and she came bouncing into our living room, and those little curls were just going everywhere, and her eyes were sparkling. And the first thing I thought was, well, hello, Curly Joe. And she looked at me with those sweet eyes and she said, Grandmother, Gracie, I not Curly Joe. That was so precious to me. I'll have that memory forever. I just wish I could tell you so much more. Gracie's grandfather and I took her on her first beach trip. When we went back to the condo, Gracie suddenly stopped walking and she looked at me and she said, Go, Grandmother, I want to live on beach with you. And that was the first time Gracie fell in love with the ocean. Gracie and her grandfather had a very special bond. She called him Pop Pop. He made a huge sandbox for her in our backyard, and she played in that. They played in it together, actually, and the two of them built sandcastles for princesses, and the sandcastles had moats around them, and they played it, had such a good time together. He also made wooden swings for Gracie to swing in with wooden bars to protect her from falling out. And she would squeal with delight, and she would say, higher, Papa, higher, higher. And he would push her higher, and her little feet would hit the leaves on the low-hanging branches. And he would say, get out of my tree, Gracie. And she would squeal with delight, and she'd say, no, Papa, no, I'm flying. Those are memories that we will have that we cherish. Pop-Pop and Gracie liked to eat popcorn and watch TV together. One day, there was a terrible odor in my house, and I came around to where they were, and they were watching TV and eating popcorn, and it smelled terrible. And I made a face, and I said, what is that smell? And they were eating the last bag of microwave popcorn, and they had, or Pop-Pop had overcooked it, and it was scorched. And they were eating it anyway, because it was the last bag available. And I made a face, and Gracie said, oh, Grandmother, it's so good. And from that day on, whenever they ate popcorn, it was scorched, because they liked it that way. Gracie loved animals. She loved all animals. She was hospitalized once with injuries that she received from trying to rescue a feral cat that she thought was under her house. She loved horses too. She couldn't afford to buy one, so she rented one, a horse named Dana. Gracie cleaned out the stalls. She fed and watered other horses. She did odd jobs around the boarding where Dana was, simply because it would be cheaper for her if she could afford to board Dana at that place. She was a hard worker. She was an avid reader. Her favorite author was Terry Pratchett. Until the day Gracie died, I thought human trafficking meant a victim was captured, sold into bondage for sexual gratification. I certainly didn't know anything about BDSM. I was naive. I never realized that a predator like Mr. Berkebile could devote a large amount of time gaining the trust of his victim so his victim would think that that way of life was normal rather than being abnormal. Gracie was so young when she connected with him. She was innocent, she was vulnerable, she knew nothing of the life that he introduced her to. She was a baby. He was an adult. What kind of man wants to have an unhealthy sexual relationship, or any kind of relationship sexually with a child? It's human nature to want to get even with someone who hurts you. I have thought of many ways I could take revenge on Mr. Berkebile. But Jesus said that we should do good things to those who hurt us or those who hurt the ones that we love. I don't know how to do that. I'm struggling with that. It's not normal. It's that kind of forgiveness that I need to give him is not humanly possible. But with God's help, I'm working on it. because Jesus commands me to love the unlovable and forgive the unforgivable and to trust in the Holy Spirit that will help me accomplish that. I hope someday I can love him. I can't right now. But I want him to know that God loves him today, just like he still loves Gracie. I have no idea what the rest of his life will be like, but I'm convinced that there are other young girls out there that we don't know about. And I'm convinced that there are other young girls that have been saved from his grasp since he's been in jail or maybe in prison. I'm grateful that there are young girls out of his grasp now. And I will pray for the young girls that come in contact with him once he gets out of prison, because that's what Gracie would want me to do. I still shop at that grocery store where I heard that unbearable, heartbreaking news of my granddaughter's death. I know the exact spot where I was standing when I heard that. I know the chair that I sat in because my body would no longer hold me up. That chair is still there, and every time I see that chair, it takes my breath away. It is hard, it is painful, and it never, ever goes away. And that's at the hands of Mr. Berkebile. I think about him, and I think about if he had never been born, our Gracie would still be alive. It's the thought I have, and the pain never goes away. A beautiful human being no longer exists because of him. He did that to her. I want to know why he allowed Gracie to pull the trigger when he knew there was a bullet in the chamber. I want to know why he allowed this to happen when she said, "You're not going to kill me, are you? I trust you. I don't want to die." But if I could talk to Mr. Berkebile right now, I would say that I hope God takes mercy on him, and that I hope whatever he does in his life, he can... I just have no other words.
Thank you, Ms. Parrish. I'm very sorry for your loss. Mr. Sanchez.
Your Honor, next we have Stephen Sparks, who's the victim's father.
Good morning, sir. I know your name and relationship, but I need you, for the record, to state your name and your
understand.
relationship.
My name is Stephen Sparks. I am the father of Grace Ann Sparks,
Go ahead, sir.
and I am sad to be here. I have a prepared statement, because apparently there are a lot of things I can't say at this time and in this place. So my wife and my mother, who you just talked to, insist that I read a prepared statement.
Okay.
And I'll try my best not to cue card it too much. The first time I heard the name Hayden Berkebile was about an hour after Gracie died. Never heard this name before in my life. And I have spent the time since then dealing with substantial grief. And I've made a conscious effort since that day to rein in my anger because I didn't have all the facts. I didn't know exactly what happened until the trial. Now I do have the facts, and I'm angry, but with far more precision. But today, at this moment, I want to talk to you about grief and anguish and pain, shame, guilt. There is no pain like the loss of regret. And anguish, well, I got all the master's class on that. There's no way to tell you about the panic attacks on the side of the interstate or crying so hard at the traffic lights you can't see it turn green. But I could sit here and tell you about being terrified to go to sleep because you know that rather than peace and rest, you're going to have more nightmares, the same nightmares over and over again. I can also tell you about diagnoses: acute traumatic stress disorder, post-traumatic stress disorder, chronic stress disorder. Oh, and of course, you can add to that anxiety and depression as well. All of this thanks to the actions of Mr. Berkebile. So one of the things I like to talk about is guilt, because the guilt comes from the fact that I could not protect my little girl from this kind of evil I frankly didn't realize existed. And that guilt comes from, well, my job is to protect her, and I didn't. And I experienced a lot of shame, an awful lot of shame, because my conscience will not allow me to take the law in my own hands. So as a result, we are here today. We've allowed the state to do what they're going to do. And my conscience requires that I accept whatever happens in this courtroom today and move on. But to that end, I would like to say that if the maximum possible sentence is truly 2 years, at the end of 2 years, they get him back. And he gets to move on. Each day, another day, farther away from what really is just a bad dream. But for the rest of us, the nightmare continues. There is no light at the end of the tunnel. It never stops. So we all effectively exist in a prison created by Mr. Berkebile. And I legitimately, when I asked the court today, what is my crime? What is my mother's crime that she should be punished so? And I don't have an answer. I don't know. And I can tell you about unproductive days at work, guilt-ridden days at work as I struggled to overcome depression and grief, panic attacks in the bathroom because you got to hide. And all of this cauldron of emotions, so to speak, is just a prison created by this monster. And of course, as we talked about earlier today, everyone so far, it's not just me or Gracie's mother. It's everybody that knew and loved Gracie exists in this prison forever. We all have a life sentence without the possibility of parole. Gracie got a death sentence. And all of this simply to satisfy Mr. Berkebile's highly specialized sexual interests. So I do want to say that I don't know if Gracie was or is his only victim. But I do know that the court today has an opportunity, at least in some small way, to help make sure that she is indeed his last. Thank you for your time.
Thank you, Mr. Sparks. Sorry for your loss.
Last, Your Honor, we have Candace Sparks, who's the victim.
Good morning, ma'am. I do, for the record, need you to state your name and your relationship to the victim.
Good morning, Your Honor. My name is Candace Sparks, and I'm Grace Ann Sparks' mother.
Thank you, ma'am. Go ahead.
One of the proudest moments in my life was as I was leaving the hospital with my youngest daughter, Grace Ann. It was a lovely March day in 2000. I was happy. I was proud of myself. It had been a trying pregnancy. The birth was fraught with all kinds of snafus, and she had to be put under the warmer, I called the French fry warmer, for several hours, delaying the time I would eventually get to hold her, examine her, count her fingers and toes, and in general just marvel at the wonder wrought by God through me. I cradled my precious child protectively and lovingly in my arms as a nurse wheeled me out of the hospital and to the waiting car and eventually to take my child home. I was the proudest mama. I had brought another life into this world, and I felt powerful, capable, but terrified all at the same time. I felt the mama bear forming inside me again, getting even stronger, and I vowed that this child will be blessed, loved, and cherished, and indeed she was. This child, along with her sister, were my gifts from Heavenly Father. Their names mean gift from God. Grace is gift from God, and she was my gift. And also on that day, I made a vow to do everything even remotely in my power, to love her, to help her feel secure and capable, and to protect her from harm. Fast forward to today. I am no longer powerful or capable. Instead, I am a shell of the woman I was before, On September 29, 2019, my world shattered. It was as if a part of me had been violently cut out and discarded. The gaping wound left in my soul and heart crushed me. Upon hearing the news that my precious girl, one of my treasures, one of my gifts, was dead, I crumpled to the floor and wailed and sobbed, and I fell into a pit of sorrow from which I haven't yet been able to escape. I too am imprisoned, but my prison is a prison of regret, a prison of despair and self-recrimination, a prison of grief so terribly crippling that I have difficulty leaving my house. The grief is incessant. I was not able to protect my child. I was not able to keep her from this type of evil. I didn't even know this type of evil existed. My child fell victim to it. And I regret that I could not protect her. I failed in my job as a mother, and I will forever, ever be tortured by that thought. This grief is demanding. It is debilitating. The grief causes me to cry when I see a young woman with blonde hair and corkscrew curls. This grief causes me to lie in a fetal position on the floor of the bathroom after a song on the radio brings a poignant and treasured memory to my mind. This grief demands that I constantly remember that my child is no longer available for phone calls about Dana the horse. Mind-numbing conversations about the horse, but conversations I treasured then and I still treasure. My child has been taken from me. I've been hospitalized in a mental hospital twice. I've been in outpatient therapy twice. I have therapy every week. I cannot function at the level I used to function at. My other daughter, Grace Ann's sister, regrets the fact that her two children, her daughters, will never know their aunt. Grace Ann would have been that crazy, fun aunt that would take you out to get your toes done and maybe a Starbucks afterwards. But those girls will miss that. Those girls will never get to experience that. None of us will get to experience the life that we would have had with Grace Ann. We have been affected forever. My prison is something I'm trapped in until my death. Why have I been confined to this prison? Because Hayden Berkebile sought a young child to exploit. He prowled the internet until he found a vulnerable young child so he could fulfill his darkest, sickest, and terrifyingly brutal sexual fantasies. He found what he was looking for in my daughter, Gracie. Then he systematically began a campaign of terror, psychological warfare, and emotional abuse designed to undermine her self-confidence and confuse her. Eventually, he was able to carry out his long-term goal of watching her die. My Gracie was a kind child. She thought very highly of others and had a great deal of respect for the differences in people, and she wanted good things for others. She legitimately wanted people to be happy. She was kind. She treated people with grace. She treated people with compassion. She was highly intelligent. There's no end to what she could have accomplished. There's no end to the possibilities that she would have been capable of. We are all poorer for her loss. Your Honor, I'd like to tell you also about one of the saddest days of my life. It wasn't September 29th, although that day was tragic. It was Tuesday, October 8th. A gentleman walked into the room I was standing in. There was green carpet. There was a big mahogany desk in the room. And I took my child from him. As I left the funeral home in Knoxville, where my child had recently been cremated, I once again cradled her in my arms, but this time I held a box of ashes containing my daughter, and I cradled her much like one would cradle a newborn, slightly gentle, a bit hesitant, and completely awash in love and blessings. But this day, my child was now a box of remains, and I sobbed there in the parking lot, leaning against the car door, cradling my baby again as I prepared to take her home. Your Honor, I beg you, give this man the highest possible sentence. Keep him off the streets. Keep him away from young children for as long as is possible. Thank you for your time.
Thank you, Ms. Sparks. I'm sorry for your loss. Anybody else, General? Very good. Mr. Loeb, defense argument?
Your Honor, may I briefly approach?
Yes, sir.
This is the version certificate for Mr. Berkebile. Proffered as needed, and also I will offer it as an exhibit as further proof of lack of criminal history, Your Honor, if no objection from the state.
Any objection, General? Do you want me to make it an exhibit, Mr. Lowe?
Your Honor, I think it would be good to make an exhibit just as, because sometimes the NCIC is included in the PSI or not. Always 100% accurate. This is further proof that an individual with the TBI has conducted the search and certified the results, Your Honor.
We'll make an exhibit, too.
Thank you, Your Honor. Your Honor, somewhat procedurally, I guess I will just begin with the PSI. Your Honor, Mr. Berkebile was evaluated by the PSI. He did come back with a strong score of moderate, Your Honor, as Your Honor is aware from your review of that document. He came back as moderate solely because of concerns they had in one area, which was residential. All of the other concerns they had would have come back in the low field. So, but for the residential concerns, it would have been rated low, Your Honor. The need that he has for residential was that he is able to live independently, but he would benefit from services, Your Honor, which is, as Your Honor, having sat through this trial, it is not surprising to you that he would benefit from services, I'm sure, with the case involved two people, both relatively young in age, who are both dealing with mental health issues and emotional issues and things of that nature. So I'm sure that's not surprising to Your Honor that he could benefit from services. That was the only moderate concern, Your Honor. All other concerns that they did have being rated as low, Your Honor. Mr. Berkebile is here to essentially determine two things, Your Honor: the length of sentence and how it will be served, Your Honor. As to length, the state has proposed several enhancing factors. I will try to address each of those enhancing factors individually, Your Honor, but I would say that some of the or almost all of them, as a matter of fact, deal with one of the state's narratives during the trial. And I say one, Your Honor, because the state opened on one theory and closed on another. I don't think the proof shows the opening theory, Your Honor, and I don't think that the jury convicted him of the opening theory. The state has made reference to a deliberate campaign of coercion and manipulation, and I've heard those words echoed in the victim impact statements. And I am concerned that the fact of the matter is the truth, and the facts, I don't think showed that. I don't think that after the proof, the state argued that in their closing. And as a matter of fact, I think they put a slide right up there on the wall that said, our argument is that he was negligent when he engaged in these games with her. I think the proof that entered at trial, both through his statement and the text, show that these were people who had made contact when they were both very young, I don't think the proof was that she was 11, Your Honor. I think the proof was that she was 13 when they first made contact. I think that's the proof that came out at trial. And I think the proof that came out at trial is they made contact via a chat website that was not necessarily a video chat that year, that it was a text-based chat that year that they first made contact. And that there is no proof that they knew each other's ages. What they knew about each other is that they had been matched in a common interest and that they both had suffered from suicidal ideation. Your Honor, she was suffering from suicidal ideation before ever meeting Mr. Berkebile, and he was suffering from suicidal ideation before ever meeting her. These two people were not the cause of each other's depression. They were not the cause of each other's mental suffering. They did, in the worst way possible, try to address that. And they tried to engage with each other to relieve the pressure towards the common goal of finding relief when traditional methods had failed them. As you recall from Mr. Berkebile's interview, he stated with Investigator Terry that he had tried therapy and it had failed, and that he felt worthless, and he thought about killing himself, and he was just trying to find someone to talk to who didn't think he was worthless too. And that is how they met. They met on the website, Your Honor. There was not a video chat in that year. It was a text chat was the proof that came in, I believe. And then the proof was that they fell out of contact for a period of years, and that during that time, they each had separate lives, with Miss Sparks meeting and eventually moving in with another man and living with him in his apartment and having contact with their family and having contact with friends. And the proof shows that Mr. Berkebile didn't try to exclude her from those things, didn't try to advise her to cut off contact with her family or even her live-in significant other, as people who are abusers often do try to isolate folks. Your Honor, I think the proof, and I only go into this because I think it addresses or is at the root of several of these enhancing and proposed mitigating factors. The proof is that while this is tragic and obviously the worst way to do it, that it does appear that both of these young people thought that this was therapeutic, even though they were wrong. It clearly wasn't effective therapy at the very least. They thought it was therapeutic, that they thought it would somehow, through immersion or through play, would somehow relieve suicidal ideations. As Your Honor was correct to point out in your Rule 29, he was playing with dynamite. That is not the way to go about it. The way to go about dealing with suicidal ideations is to get professional help from trained people, clearly. And this way was dangerous, and the jury convicted him of that dangerous conduct. He was convicted of reckless homicide, and that is dangerous conduct, as Your Honor pointed out.
Criminally negligent homicide.
Apologize,
You
Your
said
Honor?
reckless homicide. It's criminally negligent homicide.
Criminally negligent homicide, Your Honor. But as Your Honor, I apologize.
Sorry.
I guess to kind of talk about what I'm saying here, as Your Honor is aware, our criminally negligent standard is very similar to the reckless standard in civil law, and so.
Whether you were aware, whether you ought to be aware.
That's right. Yeah, so it's very similar, so sometimes I do misspeak, but they did convict him of that criminally negligent behavior, and that is what happened, Your Honor. As Your Honor pointed out in Rule 29, this is playing with dynamite. I don't think the proof showed that this was a deliberate and persistent course of conduct to mind control Miss Sparks into killing herself. Miss Sparks went to see him. She was in his home, and she came back safe and sound. When Miss Sparks did shoot herself, he looked up the number to call the local police and called them right away. I think the proof is clear that he did not want her to die, and the proof is clear that he suffered emotionally from that. This is not a cold-blooded monster who just wanted to see somebody die. I don't think the proof shows that, and I wonder about the prudence of repeating that over and over again, and I wonder if it's just more harmful to say that when that's not what the proof showed. I do think that some of the enhancement factors proposed by the state do not apply as a matter of law, Your Honor. I think as a matter of law, the second one proposed that or the third one proposed that the damage inflicted was particularly great. As Your Honor is well aware, the case law surrounding that says that what that means is that it has to be compared to the conviction offense, Your Honor. So while it is always true that a death is particularly great loss, for the offenses in which death is an element, the simple fact that a death occurred in itself is not particularly damaging because it must relate to the offense. Your Honor, in this case, while the loss is great, for all homicides, death is the loss that's prescribed, that is prohibited and punished by statute. Ms. Sparks tragically suffered a single gunshot wound to the head. She probably did not feel it. She probably did not suffer. No additional injury was inflicted upon her other than that which caused the death, for which the statute prohibits. So I think as a matter of law, that proposed enhancing factor would not apply, Your Honor. I don't believe there's a couple that kind of going together. One is the state has said that he has selected a particular victim due to vulnerability. There's a couple different ones that deal with that. I believe that the one is enhancement factor number one, that the victim was particularly vulnerable to age or condition. And in fact, the seventh one they proposed is that the victim was selected in part due to a disability, in this case a mental condition of depression or suicidal ideation, Your Honor. Your Honor, once again, I don't think those are established by the proof. I do think that she is a particularly vulnerable person. I also do think that Mr. Berkebile was a particularly vulnerable person at this time. They were both suffering from severe depression, both suffering from suicidal ideations, feelings of worthlessness, things of these nature that many people suffer with, these two unsuccessfully. But she was not selected for the perpetration of a crime for that, Your Honor. He did not select a person who was depressed to get them to kill themselves. They selected each other through a website to talk about suicidal ideation because that's what they were suffering from. He did not go to her house. He did not know Ms. Sparks' name. They met each other mutually. They both went online and were matched on a website because they were both looking for someone to talk to about these things. He did not select her for the purpose of completing a crime, Your Honor, and because he did not select her for the purpose of completing a crime, I do not believe that these enhancing factors are entitled to a great deal of weight. Even though I do agree that she is vulnerable, I don't think that he has selected her as a victim due to that vulnerability because I don't believe he intended to have her die. The state says that the crime was committed for the pleasure or the sexual gratification. Obviously, Your Honor, we all read the text. We all know this was a sexual relationship, even though it was a long-distance sexual relationship. There was no, in the text, obviously they can't touch each other or be physically present, but they are speaking, it is fantasy. Role play, I guess, Your Honor, is the best way to describe it. So there is no contention that this is not, these communications back and forth are not part of a sexual relationship, Your Honor. He is, I do think that this is entitled to somewhat less weight than an offense where the outcome was intended, Your Honor. Once again, I don't believe that the proof was he intended for her to actually die. And I don't believe he intended to see her die as a period of to die for his sexual gratification, which is a statement that's been repeated over and over again, Your Honor. But I think all the proof shows that he intended to carry on having this type of relationship with her well into the future. I don't think he intended her to die. I think that in his mind they were probably going to carry on just like this ad nauseum for as long as they knew each other in this type of role play. The state said he had no hesitation about committing a crime where the risk to human life was high. Your Honor, this is somewhat different than the basis for consecutive sentencing in its analysis. It has fewer moving parts to it. However, Your Honor, what is, as someone who predates the internet by just a little bit, maybe I don't know, maybe I'm untouched, but like, what is the risk for something like this? We know what happened now. The risk in this case is 100% because she did die. So we know what happened now. But as an enhancement factor, is for someone who's given an interview to the police and was suffering himself, and we have no reason to disbelieve the explanation. In fact, the proof tends to support that these two people were engaged in this as sort of seeking relief. In what way would they know? We know now, but in what way would he be aware that the risk was high? On the fourth time they did this, how would he know it would be any different than the 3 times before where no one died, or the 5 times before when no one died, or the 8 times before when no one died, Your Honor? We know now because we are both of sound mind and we are not suffering from depression and we are not suffering from suicidal ideation. It is very easy for us to look at it from the outside and say, Jesus Christ, this is dangerous. But for these folks suffering from these things where they are feeling a little bit of relief, I don't know how he evaluates that risk. And I don't know we can say he had no hesitation about committing a crime where the danger was high when the danger may not have been obvious to him, Your Honor. I don't think that precludes it from having any weight, because I don't think it's a subjective standard. I think it's an objective standard, Your Honor, so I think it is still appropriate to give it weight, but I think it would be appropriate to give it less weight where it might be the case that subjectively he would not be as aware of it as someone who is of sound mind. Your Honor, the state says that he was abusing a position of private trust, and that is true that they did trust each other, Your Honor. Obviously, they were any time two people are in a sexual relationship together, they do trust each other. I think that is not entitled to a great deal of weight, because any time two people know each other and they have an even friendly relationship, it can be said that they trust each other, Your Honor. He was not in a position of particularly powerful position over her, Your Honor. He was not living with her. He was not seeing her every day. He did not control her finances or control her day-to-day going-ons. And so while she did trust him, he lacks all of the normal things associated with that level of trust that would necessitate putting a great deal of weight to that enhancement factor. Your Honor, as mitigating factors, I would propose that Mr. Berkebile did. The crime was partially a result of his lack of judgment due to either age or condition as part of the catch-all, Your Honor, and I do think he was suffering from mental conditions that obviously impaired his judgment, and his relatively young age compared to us obviously impaired his judgment, Your Honor. He was suffering from depression. He was suffering from suicidal ideations, feelings of worthlessness, and those things, Your Honor. Another enhancing factor is that he assisted authorities in uncovering the offense. The truth of the matter, Your Honor, is if he did not call the police, if he did not look up the number and call the police, I don't know that Mr. Berkebile ever would have been charged. I don't know that they would have figured out that Facebook happened if he didn't say I was just on the phone with her. I don't know that they would have ever charged him with anything, or they ever would have known. And if he really was a person who just wanted to watch someone die, that's probably exactly what he would have done, is sat there and told nobody and just hoped they didn't catch him. But he did assist authorities in covering the commission of what ended up being this offense, Your Honor. He called them right away as soon as he could figure out the number. And he told them his identity. He told them that he was just on the phone with her. He told them, I believe he told them where she would be, what her name was, and that he thought that she just shot herself. And so he did assist the authorities substantially in detecting the commission of this offense, Your Honor. The last mitigating factor that I think applies here is that this was done under such unusual circumstances that it's unlikely he has a sustained intent to violate the law. I understand that the state has implied or outright argued, and we've heard, that there must be other people and that we're saving people if he doesn't get out. But the truth of the matter is there's just absolutely no proof of any of that. There's no proof that there's any other victims. There's no proof that he's ever even talked about suicidal ideation with anybody other than Miss Sparks. There's no proof he shared that feeling of suicidal ideation or depression with anyone else. There's no proof whatsoever that he is in fact a predator. In fact, his rating for attitudes, behavior, and all of those things came back low. Aggression came back low on his PSI, Your Honor. There is absolutely no proof that there are other victims out there. There's absolutely no proof he engaged in this type of particular suicide role play with anyone else. And so I understand that we hear that being said, Your Honor, but the fact of the matter is there's no proof in the record of it. It would be inappropriate to rely on that, saying that he had some sort of sustained intent to violate the law. So I do think given those circumstances, it is very likely he did not have a sustained intent to violate the law. He probably didn't realize that he was in danger of violating the law to begin with on September the 29th. Also, Your Honor, I am well aware now, after this has happened, and after he has been charged, and after all the conversations we have, he is well aware now that that is not the way to deal with it. He is well aware now of the serious problems that he had mentally. He's well aware now of what he needs to do to correctly deal with those feelings of worthlessness and those feelings of depression. And in that sense, his circumstances were unusual in that he has no illusions whatsoever now that he can deal with his emotional state by himself, that he does need help. He knows that. Whereas before he thought that it would not work. And so, Your Honor, for those reasons, those would go to length of sentence, Your Honor. As to length of sentence, Your Honor essentially only has two choices. It's either 1 or 2 years, Your Honor. So even though I do think in this case the mitigating factors outweigh the enhancing factors, I would say, given the circumstances of the offense, anytime a young lady dies and your only two choices are 1 or 2 years, I think Your Honor obviously only has one choice, and that's 2 years, just to be candid. So with only having two choices here, I believe that your only choice, your only real choice here, even though I do think mitigation outweighs enhancement in this case, is that you have to pick 2 years. Anytime a person dies, that merits at least a sentence length of 2 years, in my opinion, barring some sort of thing that's not a crime, just like a normal traffic accident where it's just simple civil negligence, Your Honor. But what does need to be determined is how he will serve that and what we will do pending appeal, Your Honor. And I would like to make arguments on how he will serve that first. Your Honor, he is a man who is diversion eligible. He has absolutely no criminal history. And I do believe that he is amenable to rehabilitation. People who suffer from mental illness can be rehabilitated. We do have hope for those folks. He has family support, as was noted in his PCI. Also, as Your Honor was aware, he has family support from seeing him in his trial. And he does have family here today as well, Your Honor, that have driven down to support him. He does have family support, and they can help him continue on these services. Your Honor, he had begun therapy prior to the trial. And obviously, as Your Honor is aware, he was a person who lived out of state. He was compliant with court orders. He came back to trial. He came back to a multi-day trial, Your Honor. He was submitted to the jurisdiction of the court and did not commit any additional crimes while a pending trial, and generally does show the ability to be obedient to laws and obedient to lawful orders, and has a healthy respect and attitude towards authority, as indicated by his PSI, Your Honor. And so I do believe that this will be Mr. Berkebile's only ride with the criminal justice system, so to speak, Your Honor. I think he gets it. I think he is able to comply with society's expectations and will do so. Your Honor, is as much as everyone would not like it, I think the law would say he is amenable to rehabilitation. I think the law says he is appropriate for diversion. I think when we consider the factors and look at it, the fact that he is now aware to get therapy and he knows how to do it, and demonstrated the ability to successfully engage in therapy and live a normal life for the years that the trial was pending, shows that his mental health is such that while it did lead up to the commission of this offense, he does understand how to control it now when we evaluate his mental health. I think his physical health would not weigh one way or the other. He's just a normal human of normal physical health, so that does not weigh one way or the other in diversion, Your Honor. The circumstances of the offense are, of course, the most serious consideration in this case for diversion, because it involves the death of a young lady. Your Honor, the legislature has indicated that negligent homicide is a case that can be diverted. And so as much as that seems strange, the fact of the matter is they have considered that there are some cases in which death occurs in which a person can still receive diversion. Your Honor, I am aware of the case law. I don't know if it's been mentioned yet, but I am aware of the case law in Tennessee that says for negligent homicide cases, sometimes just the circumstances of the event themselves can outweigh each and every other consideration when it comes to diversion. It also says that when it comes to confinement, as Your Honor is well aware. And while this is tragic, it is got to be one of the two saddest cases I've ever been involved in, Your Honor. I think they're both with you, actually, unfortunately. But this is not, as everyone's been led to believe and has been reported. He is not a monster. He did not want her to die. He, while certainly will not suffer as much as her family will, because they're her family and they're the ones closest to him. The truth of the matter is he does suffer because of it. He did have a deep connection to this person, and even though it was a terrible way to do things, they did bond and they did experience some relief of their suicidal ideation together. And so he did suffer, and he will continue suffering for the rest of his life for that, Your Honor. I do think he is diversion eligible, and I do think that that is appropriate. If Your Honor looks at the case law and in your discretion thinks the circumstances of this case just warrant that this stay on his record, I still do think that he is an acceptable candidate for probation, Your Honor. I do not believe he will reoffend. I think the court will exert a lengthier period of control over him on probation than they would if you sentenced him to serve, Your Honor. I think you would actually be done with his sentence very quickly if he were sentenced to serve, so quick that he would probably serve it before his appeal was even done. Truthfully, Your Honor, I think he would be done with his sentence so quick it would be done before his motion for new trial was heard. And so I think you will exert a greater length of control over this defendant through probation than you would by sentencing him to serve. And I think that the control you can exert over him can be more detailed and fine-tuned than it would otherwise be on something like determinate release, where it's kind of a one-size-fits-all approach when that happens, Your Honor. And so I do believe he is appropriate for diversion, and I do think that he should receive a sentence of 2 years on diversion, Your Honor. I believe it's probably appropriate to address the appellate bond after the sentencing, not before, I suppose.
All right. Mr. Berkebile, you are not required to say anything. You are given an opportunity before the court decides the appropriate sentence in your case. This is your opportunity. Is there anything you'd like to say, sir?
Yes, sir.
All right, you may begin.
I want to apologize for the part I played in your grief, anger, and mourning. Through my negligence, we lost one of the brightest lights in this world, and for that I will never be able to say sorry enough. I do wish you know I never wanted this, and that her death was never my goal or intention or my actions. The memory of her still haunts my dreams, and the event of this September 29th still haunts my nightmares. She was the very best of us, most beautiful, funny, caring, compassionate, and sassy human I've ever met. And I know you all feel the loss even more than I do. Again, I'm so sorry, and I would give anything to give Grace back to you.
All right, thank you, Mr. Berkebile. So I want to review what has been argued this morning. It won't take me long, but I would like to take a recess for about 10 minutes, and we'll come back at that point, and the court will enter judgment. 10-minute recess, folks. Can we just join in chambers?
Mic check on the podium. Mic check on the podium. The rest of this.
Ready, Christy? You can have a seat, folks. All right. Good afternoon again, everyone. Thank you for that break. I wanted to take an opportunity to review what had been argued this morning and put some things on the record before I enter judgment. I always start in these homicide sentencing hearings by addressing the victim's family. It's always difficult to sit up here as a human being and listen to the pain of other human beings and not be able to offer you some form of comfort. But that is not my job today. My job as a judge. And so what I'm getting ready to say is going to sound cold and calculating to you, and that is because it is. Because the job of the judge is to be a neutral and detached magistrate and enter judgment according to the law and the evidence in the case. Your victim impact statements certainly were moving to me. I certainly understand and appreciate your grief, and I wish that there was something I could either do or say that would relieve that from you. But as you, I'm sure, are aware, that the sentence that is available for Mr. Berkebile is one that you're probably not going to be happy with. And probably, if I gave him a sentence of 50 years, if I could, it would not ease the suffering that you are feeling. And I am very sorry for that. I know that as a human, you have my deepest sympathy, and I'm sorry that you are here. But my sentence does not take into account the value of Grace Ann, because as wonderful as a person I'm sure she was, the law, not only in the state of Tennessee but in Iron Country, takes any homicide as serious, whether or not the person was a great contributor to society or somebody who had never contributed anything. And so when I talk about these enhancement factors in mitigation, I don't want you to hear me saying that these legal concepts are more important to than Grace Ann's life was. It's not. It's just that's not the factors that I consider. So I'm just going to start with that. Now, the court is presented with really three questions today. One is whether or not the defendant should be granted judicial diversion, which would allow him to avoid a conviction on his record and could get this expunged from his record. The court is also tasked with determining the length of the sentence as well as the manner in which that sentence would be served. To begin with, the defendant was convicted by the jury of criminally negligent homicide. That is a Class E felony in Tennessee. The defendant has no prior history, so he is what we call a Range 1 standard offender, which means the possible range of punishment is 1 to 2 years. And this is a 30% sentence offense. And so what that means is if he is ordered to serve a sentence in the penitentiary, he has to serve 30% of that before he's eligible for release. Under the law in Tennessee, since it couldn't be more than a 2-year sentence, it would automatically be released after 30% of that sentence, which is just a little bit over 7 months. And so I'll begin with judicial diversion. The defense is requesting for the opportunity to be placed on judicial diversion. They have submitted a certificate from the Tennessee Bureau of Investigation indicating that he does in fact qualify for judicial diversion. Criminally negligent homicide is an offense that fits under the statute as being eligible for diversion. There are certain factors the court has to consider. One is the defendant's amenability to correction. The defendant has some positive things going on in his life and has, as Mr. Lowe has set forward. He has, as I said, no prior criminal history. He's maintained employment through a good portion of his adult life. He does have family support. Obviously, he has some mental health issues that could be addressed. So with no prior criminal histories to lean upon, the court certainly must find that he has some amenability to correction. The circumstances of the offense weigh against granting judicial diversion, even though, and I'll talk about this a number of times, I don't believe that this was an intentional or knowing homicide. If so, this would be second or first degree murder. It's still a repeated act where the defendant knew or should have known that his conduct was placing another life in danger. And so I do believe that the circumstances of the offense strongly weigh against granting judicial diversion. As I said, he has no prior criminal record. There's nothing in his social history that would cause the court concern one way or the other. As Mr. Lowe said, there's nothing about his physical health that would weigh one way or the other on that. His mental health, he obviously has some issues that perhaps are treatable, and the deterrent value to others and the defendant, I do believe that this is not a common case for the court to consider. This is the first time I've ever had a case like this, and I think that it probably goes on a lot more than we're aware of. We just rarely find out about it, either before or after the death of the victim. And so I do think that this is a behavior that occurs frequently but does not result in death, where there is statements being made online either in a bullying nature or, in this case, an opportunity or a desire to seek gratification. I do think that it would be less of a deterrent value to others if diversion would be granted in this case. As Mr. Lowe said, I don't imagine Mr. Berkebile would engage in this conduct again. I just don't know. It went on for a long time. Who knows what's going to happen after this? And finally, whether the interest of justice can be served to the public and the defendant by granting judicial diversion. That's really sort of the overriding decision the court has to make. And based upon the facts of this case, I do not believe the interest of justice would be served by granting the defendant judicial diversion. Therefore, I'm going to deny his request for diversion. So the next issue to address is the length of the sentence. In order to determine the length of the sentence, the court, after establishing the range, which I've done is range 1, there are certain enhancement factors the court can consider to give guidance in that length, as well as some mitigating factors. Both sides have argued, so I'm going to go through what has been presented this morning. The first enhancement factor the state has cited under 4035-114 is subsection 4. A victim of the offense is particularly vulnerable because of age or physical or mental disability. I do believe that that enhancement factor applies here because it's been established through the proof the defendant initially selected his relationship with Grace Ann because of their both wrestling with suicidal ideation. And so he knew she was vulnerable, and I disagree with Mr. Lowe that he didn't select her for that reason. I think he absolutely selected her for that because that is how he was getting his sexual release, from that vulnerability. And I think she was particularly vulnerable. I think someone without the struggles that Ms. Sparks was going through would not have been susceptible to the defendant's manipulation. And so I do think that enhancement factor does apply here. The fifth subsection, the defendant treated or allowed a victim to be treated with exceptional cruelty during the commission of the offense. The general public would hear that and think, oh yeah, obviously that's a cruel way to treat somebody. But when you look at the case law on this, usually what we're dealing with here, and you'll mostly find this in death penalty cases where there's been a first-degree murder conviction, it's the person does things with the intent to cause pain to that person. Now, I'm not saying he didn't intend for her to feel what he was expressing as pain, but I don't think when you look at the case law that this comes anywhere close to what other cases have found exceptional cruelty. It's aberrant behavior, and certainly would fall under the definition of cruel, I believe, but under the legal case law that has been established in Tennessee, it doesn't come close to what those cases are contemplating. So I don't find that enhancement factor applies here. Number 6, the personal injuries inflicted upon or the amount of damage to property sustained by or taken from the victim was particularly great. As Mr. Lowe said, that cannot apply here because one of the elements of criminally negligent homicide is the death of the victim. So you have to go beyond that. So I don't think that can apply under the law here. Subsection 7, the offense involved a victim was committed to gratify the defendant's desire for pleasure or excitement. This is one the prosecutors request frequently, particularly in child sex cases, found that this enhancement factor applies until now. I think this case is exactly what is contemplated by this enhancement factor when our legislature put it in. Mr. Berkebile was clearly engaging in this conduct for the purpose of his sexual gratification and desire and pleasure. And it's easy in this case to get confused with the word intentional. I certainly believe Mr. Berkebile intentionally communicated to Grace Ann what he wanted to communicate. I don't think he intended for her death, but I don't think it matters in this case. It's irrelevant whether or not he wanted her to die or didn't want her to die. What is relevant is, did he intend to send these messages, and a person sending those, what was their motivation, what was their intent? And his intent, I believe, and I think it's strongly supported by the record, was to gratify his own desire, regardless of the consequences to Grace Ann. And so that enhancement factor, I think probably for the first time in 11 years, I've actually found that that one applies, but I do believe it applies, is entitled to a great deal of weight. Number 10, the defendant had no hesitation about committing a crime when the risk of human life was high. That enhancement factor cannot apply when you have a named victim in the indictment. It must be danger to somebody other than the named victim. In this case, Grace Ann Sparks was our named victim, and there's no evidence that his behavior created a risk of danger to anyone other than her, so that cannot apply here. Subsection 14, the state argues the defendant abused a position of public or private trust or used a professional license in a manner that significantly facilitated the commission or the fulfillment of the offense. This one, to me, was a close call. I do think Mr. Lowe probably has the better argument on that it was a close personal relationship, more of a peer relationship, though, than what we generally find as a position of trust. When we're talking about a position of private trust, you're usually talking about a parental authority figure or a babysitter or a teacher or something like that. They, even though they had this master and subservient level relationship, I don't think that could be classified as a position of private trust. So I'm going to find that enhancement factor does not apply. And lastly, number 17, the defendant intentionally selected the person against whom the crime was committed or selected the property that was damaged or otherwise affected by the crime in whole or in part because of the actor's belief or perception regarding the race, religion, color, disability, sexual orientation, national origin, ancestry, or gender of that person or the owner or occupant of the property. And so this is basically our hate crime enhancement factor. I certainly get the state's argument about disability, her suicidal ideation being that, and that he certainly selected her for that. But I don't think this is what the legislature was intending when they contemplated this hate crime enhancement factor. So I don't believe that that applies under the law. To summarize the enhancement factors, I do find that subsections 4 and 7 apply and are are entitled to a great deal of weight. The defense has also argued some mitigation, mostly under the sort of the catch-all number 13. Some of these are related to listed enhancement factors under mitigation under 4035-114. The defense argues that the defendant, because his age lacked substantial ability to make wise judgments or sound judgments in this case. The defendant was certainly not old, but he wasn't a juvenile either, and I don't think that his age really played much of a role at all in his judgment in this case. He'd been employed, had graduated from school, and so I don't think his age really had anything at all to do with it, so I don't find that mitigation applies. The defense also argues that he did call the police, and that is true, that he could have just turned his phone off and hope nobody ever says anything to him. And so that was the right thing to do, to call the police, and I will consider that as mitigation. The defense spends good portion of their time arguing that he had no sustained intent to violate the law. I would disagree with that. I understand your point, Mr. Lowe. I don't think he had a sustained intent for her to die, but I do think he had a sustained intent to continue engaging this behavior with somebody who was extremely vulnerable, and he ought to have been aware that his conduct would lead to the death of Ms. Sparks, and so he committed multiple acts of, if it was such a thing, of attempted criminally negligent homicide, which that's not a crime, but he did it a lot, and it's probably a miracle that it didn't happen earlier than it actually did, the way that they were playing. And so I think he did engage in this intentional conduct for a long time, but I don't disagree with you, Mr. Lowe, that he didn't want her to die. There was a lot of evidence in the messages that they had sent back and forth where he actually was trying to talk her down and tell her that her life was worth living, which is just further baffling to me on why he would, knowing that, would continue to engage in this type of behavior. And Mr. Lowe also argued that he couldn't have known that the risk was any greater at this particular time when she did actually pull the trigger with a bullet in the chamber. But I disagree with that. I think he should have known. She told him that day how close she was, and she would give him these numbers about the depth of depression and how close she was to to suicidal ideation. And she gave the highest numbers that I recall giving, and gave him all kinds of warnings, not the time to push. And yet he did it anyway, and he did it because he simply wanted to have some sexual release. And so when you look at the enhancement factors and the mitigation, I find that the enhancement factors greatly outweigh the mitigation, and therefore the only appropriate length of the sentence would be the maximum sentence of 2 years. So the last issue before judgment is entered is determining the manner in which the defendant should serve this 2-year sentence. I've already denied diversion, but he is eligible for probation. Mr. Lowe argues that he should be granted probation. That would give this court longer time to sort of keep supervision over him, because he will be released fairly quickly on a penitentiary sentence. But the factors the court is supposed to determine under 4035-103 is confinement necessary to protect society by restraining a defendant with a long criminal history. Obviously, the defendant has no criminal history prior to this. Therefore, that factor would weigh in favor of the grant of diversion. Is confinement particularly suited as an effective deterrence to others for similar crimes? I don't know that I have really ever relied on that one to send somebody to the penitentiary, but I do think that actually applies here. There has been extensive media coverage of this case. It is a unique and novel case, but as I said, I think this behavior occurs a lot more than is brought before the criminal court in the form of abusive online behavior, either through bullying or this type of direct sexual contact, sexual messages. The court frequently is exposed to online predatory behavior toward children, and so I do believe that confinement sentence, when it's this type of an event where somebody is using the internet to engage in behavior that is destructive to other human beings, I think that does weigh in favor of confinement. Have measures less restrictive frequently or recently been tried unsuccessfully? Obviously, no. He's never been on probation before or been in the penitentiary. That weighs in favor of probation. And what's his potential, lack of potential for rehabilitation? That, again, is a difficult one for this court to assess. He obviously does have some mental health and emotional needs that could be addressed through counseling. I do believe he's sincere in his remorse, and so I think he probably is amenable to some form of rehabilitation. And lastly, is confinement necessary to avoid deprecating the seriousness of the offense? And I certainly find that weighs in favor of confinement. This wasn't an isolated incident. The only thing that was isolated about it is on this particular day, the round in the gun happened to be in the chamber that was getting ready to fall in front of the hammer. That's the only thing that was isolated in this over the last couple of years of Grace Ann's life. And so I believe that the position the defendant was in as far as being the master to a subservient young girl, knowing that she was particularly vulnerable because not only of her age, but more particularly because of her emotional frailty, that he would use that, this whole idea of somebody committing suicide to achieve sexual release is the height of evilness in this court's mind. And I believe that if the law permitted, a sentence of 2 years would be warranted, greater than 2 years would be warranted. However, I'm limited by the law to 2 years. And the family expressed a word several of you talked about being in prison. And I understand that. And it's not my job to give you any spiritual advice, but several of you talked about your faith in God and how he calls you to forgive. Whether or not you forgive Mr. Berkebile has nothing to do with what I do as a judge. You can get up here and say, Judge, be lenient, let him go, and I'm going to do the same thing. Or you can say, I want him a life sentence, and I'm going to do whatever I'm going to do under the law. But one thing that I will tell you, forgiveness generally has more to do with releasing yourself than him. If you let this man and his evilness consume the rest of your lives, then he's going to do more harm to you than he already has. Now, that's up to you how you want to relate to him and deal with him. But one thing I might encourage you on, I've had several people sitting there where you are over the last 27 years of being involved in the system. And some of them have seen something in the system that can be changed. And I know that you don't live here in Tennessee. Most of you don't live here in Tennessee. But one of the things that brings relief to some of the victims' families is they've become advocates and support for other people. And I believe that this case, as well as others, could be an effective springboard to get the law changed for this type of online abusive behavior. And so I would encourage you to explore that. I'm a member of the judiciary. I'm not a member of the legislature, so I have no role in that. I certainly would encourage the legislature to look at these type of offenses and realize the danger that these type of internet abuses are having, not only on children, but on adults as well, too. And so all that being said, the court does find that the appropriate sentence is the maximum under the law, 2 years to serve. So at this time, Mr. Berkebile, if you'd stand up, I'm going to enter judgment. Hayden Jennings Berkebile on docket number 117131, after being found guilty by a jury of your peers of criminally negligent homicide, the court now sentences you to a maximum sentence of 2 years to serve as a range 1 standard offender. In Tennessee, you have to serve 30% of that, and you will be released after 7 months and 6 days. You've already served 91 days of that, which you will be given credit for. So you can have a seat now, sir. Now, Mr. Lowe, I am certainly aware that he is going to quickly get to his release eligibility date as a determinate release offender, and I understand you're going to ask for an appellate bond. Is that correct, sir?
Yes, Your Honor. Would you like me to speak on that now?
Yes, sir.
Your Honor, we would request an appellate bond in this case. As an E felony, he is, of course, not entitled to an appellate bond, but he is eligible for an appellate bond, Your Honor. He finds himself in the circumstance where he is opposite of what we normally see in these situations, Your Honor. Normally, what we see when asking for an appellate bond is someone has come to trial with the possibility of being free and is now facing a lengthy sentence. He actually appeared at trial facing a greater sentence than he now faces, Your Honor. The C felony was obviously dismissed, and he only has a couple months remaining in jail, Your Honor. His exposure has decreased. When his exposure was much higher, he was compliant and appeared and submitted himself to the jurisdiction of the court. Now that his exposure has decreased substantially, there's absolutely no reason to believe that he would not continue to do that, Your Honor. Mr. Berkebile, when he was facing a possible sentence of 8 years, showed up, Your Honor, and submitted, drove in from out of state to come and submit himself to the jurisdiction of the court. Now that he is facing a remaining sentence of a few months, it is there's no reason to believe that he would not continue to submit himself to the jurisdiction of this court when he's done so faithfully up to this point, Your Honor. Also, I do believe that the trial bond was made through A1 bonding, Your Honor. I have had contact with A1 bonding at the request of my client just to confirm their willingness to take a bond for him if one is set by Your Honor, and they have confirmed that they would be available, that he was compliant with their request and instructions, and had a good business relationship with them, and that they had no concerns about him appearing and submitting himself to further orders and conditions of the court, Your Honor, whether that be this court or the Court of Criminal Appeals. And so I do think that he is eligible for an appellate bond, Your Honor. I think he finds himself in a situation where a low bond would be sufficient to assure his appearance. And quite frankly, Your Honor, I think that if he were simply released, he would come back. I don't know that any bond would actually be necessary to assure his appearance. He intends to comply, and he intends to be obedient to the court's orders, Your Honor. But if you were to set a bond of $1,000 just to make it a monetary bond, he will be back as sure as he would as if it were higher, Your Honor. He intends to be obedient to the court's orders. He's been obedient to the court's orders in the past when he faced much greater exposure, and I believe he will continue to be obedient to the court's orders in the future.
Was the original bond 30,000? Is that what it was?
I believe the original bond was probably 100,000, Your Honor.
100,000. Okay. All
But
right.
I don't feel that such a bond would be necessary. Again, he was very compliant, obviously, Your Honor.
Thank you. General, would you like to be heard?
The state's requesting that Mr. Berkebile be denied bond pending his appeal. Mr. Berkebile is now presumed guilty, and this court has discretion under TCA 40-35-116 to not deny bond pending post-guilt determination hearings. While Mr. Berkebile has the right to appeal his conviction, that right does not guarantee a stay of his sentence pending the pendency of his appeal. He is no longer presumed innocent, and thus his incentive to flee the jurisdiction and not return is heightened. Mr. Berkebile resides in Indiana. He has no ties to the community. His only connection to Knoxville was his online communications. Further, his actions leading to this conviction showed propensity for anger and impulsive behavior that endangered others. His crime was committed entirely online, and the ability to monitor his activities, ensuring he does not repeat this offense or commit further offenses, is improbable. The court has the discretion to deny bond accordingly. The state requests that you deny Mr. Berkebile's bond pending appeal and that he continue to be held in state custody.
All right, thank you, Joe. So the issue on an appellate bond is different than everything I just said. The court doesn't look at the circumstances of the case and all those other issues. It's a different things the court has to consider. And so you have to determine whether or not if the denial of bond would have could cause irreparable injury if the defendant is entitled to a new trial in this case. What that means is basically if he remained in custody pending the appeal, would the appellate courts be able to afford him relief from the damage that was done? And I believe this case was well tried by both sides. There were certainly some legal issues raised. I think the weight of the evidence is going to be the most significant issue on appeal, and this is a unique case. The appeals, as Mr. Lowe said, are going to take a lot longer than his release would be from the penitentiary. So he's looking at 7 months and 6 days before the 30%. As I said, he's already done 91 days of that. That's almost certainly going to be before we got to the point of being able to hear the motion for a new trial. Therefore, if he was wrongly convicted, which I don't believe he was, but if he was, then he would really receive no relief from the appellate court other than the conviction being overturned. He will have done most, if not all, of the sentence by then. So I do think that an appellate bond is warranted. However, when the court considers the amount of the bond, I'm also considering the safety of the community. And my biggest concern with Mr. Berkebile is not that he is going to assault somebody or he's going to go sell drugs or rob a convenience store. My concern with Mr. Berkebile is that he's going to be online and having damaging conversations with other vulnerable people. And so the court can grant and set bond conditions. And as I've been wrestling with how to do that, the only bond condition that I'm comfortable setting to ensure the safety of the community is that he have no internet access. And the only way I can ensure that is as if he's on pretrial supervision with Knox County. And I know he's a resident of another state, but as I weigh the factors of where bond should be set, the only way I'm comfortable with him on an appellate bond is if I can supervise him and make sure he's having no internet access, which means he will have to reside here in Knox County until his appeals are done. So he very well may choose not to post the bond I'm getting ready to set, but I am going to set an appellate bond. I don't think $100,000 is necessary. As Mr. Lowe said, he's appeared before. He doesn't have that long to go on his sentence, and if he failed to appear, he'd end up causing more trouble in his life than he already has. And so I don't think the amount's that significant. I'm going to set it at $25,000, but I am going to place him under pretrial supervision. I'm going to require that he establish a residence in Knox County so he can be monitored by the Knox County pretrial officers. I'm going to order that he remain free from any new criminal charges, that the residence he establishes will be subject to search by pretrial officers at their discretion and any other law enforcement officer, that he'll report as directed to his pretrial officer, he'll submit to random drug screens, and as I said, have no internet access. He's not allowed to have a smartphone and no internet service in the home. And so he will have to get a flip phone to have access to cell or phone communications, or a landline, but there will be no internet access while this appeal is pending under this appellate bond should he choose to make it. If he doesn't make it, then he'll come out on term of release, and then he'll just be under the supervision of whatever TDOC sets for him. But that will be the court's order on bond. Now, the next stage in these proceedings will be the setting of the motion for a new trial. We will need to get the transcripts prepared because they have to get to the Court of Criminal Appeals within 60 days of the court hearing that motion for a new trial. And so, Ms. Andrews, do you have a time frame for me on when you think, assuming Mr. Lowe requests that?
I will, Your Honor.
Consider it request. Okay. So this is July, 1, 2, 3. Let's assume that Mr. Lowe gets the transcripts in early October, let's say. Could we set this for hearing on Friday, November 18?
It's a good day for me, Your Honor.
General. Folks, that hearing is a motion for a new trial. What happens for the appellate process is before the case gets up to the Court of Criminal Appeals, the defense has to file a motion to this court outlining all the issues that they believe, and then I consider that first. And so we'll come in, each side can present proof if they want to. Usually it's just argument. And then the court will decide if the judgment should be set aside and a new trial granted. If I deny that, then it goes to the Court of Criminal Appeals. So I'm looking at November 18th of this year. Will that work for y'all? Is that good? I'm assuming it is. All right. So we'll set this for motion for new trial hearing on November 18th. Any other issues from the state?
Nothing.
Anything else from the defense?
Not that I can think of, Your Honor.
All right, I'll have pretrial come up and talk to him in case he can establish his Knox County residence. All right, court stands in recess.